Good evening and welcome to Law and Order, brought to you exclusively by Channel I. Tonight we carry on from last week when we commenced this discussion on vertical living, the ownership of apartments or a condominium parcel. And joining us once again tonight is none other than an expert in the field, Ms. Ajitha Edrimanna. Thank you, madam, for joining us once again on the show. Ms. Edrimanna counts more than 33 years as a lawyer, during which time she has covered this entire area of law extensively and has even written a book titled Understanding the Concept of Condominiums. She is invited by various professional bodies to lecture on this topic because it is a hot topic these days. Like I mentioned last week, the skyline of Colombo is changing drastically, with numerous high-rise buildings coming up every month, and some of the topics that are relevant to this area is something that is relevant to all of us, which is the ownership of these apartment complexes and a condominium parcel. So carrying on from last week, ma'am, if you could, for the benefit of those who could not join us last week, just run us through the sequence that is followed when a purchaser wishes to become an owner of an apartment. An apartment.
Thank you once again for having invited me. As I told last week, in the case of a condominium unit, there is two types of ownership. That is the ownership in relation to the unit and also co-ownership of the common elements, yes, which are not part of the units of a subdivided building. So, first of all, a developer would offer a sales agreement at the time of construction to a prospective purchaser. So, once the sales agreement is signed after about 2 or 3 years, when the building is completed in accordance with the approved building plan and the certificate of conformity is issued, along with all the other documents that are necessary to register a condominium property, the developer's lawyer would submit it to the land registry, and then when it is registered, that is, each of the units will be registered in a separate folio at the land registry. Thereafter, the deeds of transfer can be done.
That's the basic sequence that is followed.
Yes.
Now, ma'am, you mentioned common elements. For the benefit of our viewers who may be first-time owners or who are about to become first-time owners, what exactly are common elements?
Now, common elements in a condominium property are all those areas which do not form part of a unit. Units are those areas which are habitable in which a person can live, which would be perhaps subdivided into 3 or 4 rooms and which can be used independently. So, if you leave out all the units, the rest of the areas are called common elements. Corridors, swimming pools, playgrounds, the lifts, parking, all those are common elements. Now, one would wonder how would these common elements be managed?
Yes.
At the time of registration of a condominium property, when the deed of declaration is registered at the land registry, automatically a legal entity called a management corporation comes into existence. It also has a name. Most people are not aware of it, but it carries part of the condominium plan number. So, for example, if the building is based on condominium plan number 1234, let's say, the management corporation would be called Management Corporation Condominium Plan number 1234. So, there is a name for this legal entity. Now, this entity has a lot of powers as given in the apartment ownership law. These powers are necessary to manage and maintain the common elements. It's such a vast area, and for people to live comfortably in this building, the common elements must be properly managed.
Of course.
So, and if it is not properly managed, the value of the unit would also go down. So, now who are the members of this management corporation? The members are all the unit owners. The entire number of unit owners automatically, when they get the deed of transfer, becomes a member of the management corporation. But all of them together cannot manage the common elements. So the Act allows, first of all, for the Condominium Management Authority to hold the first annual general meeting.
The Condominium Management
The
Authority.
authority convenes the first annual general meeting.
Right.
That would be done within 3 months of registration of the condominium property.
Right.
So they are just the convener, right? And then during that first annual general meeting, a council is appointed from among the unit owners, the ones who can really do proper service to the condominium property would be appointed. Thereafter is the council, like a board of directors of a company, which administers and manages the common elements.
Now there is also something called a management fee. What is it? What exactly is this management fee? Because sometimes, you know, when a buyer purchases an apartment, sometimes they might think that that is all they have to pay. You know, maybe the monthly loan installment, but then they find that there is also this additional fee that has to be paid. What exactly is this management fee, ma'am?
That's something most people overlook.
Yes.
When they go ahead of you know, they want to buy a condominium unit, because mainly because of the location, they think, okay, it's the loan interest, loan installment, and the sale price, that's all. But once you move into the building, because you not only acquire the unit, you become a co-owner of all these vast areas called common elements. So you have an obligation to contribute to its maintenance. And that contribution is what is called a management fee. There are different terms: service charge, maintenance fee, whatever they may call it. So that the management corporation or the council cannot just determine a management fee. They take into account the entire expenses that would be incurred in maintaining and managing the common elements, like cleaning up the swimming pool, cleaning corridors, so much vast lot of things that needs to be done, the lifts, so on and so forth. And then they would ascertain what amount of revenue that has to be raised. So this total expenses would be more or less equivalent to the revenue that would be raised, and the proportion of that revenue would be charged to each unit owner, which is based on the share value that is assigned to the unit.
Yes. So now, ma'am, after all the apartment units have been disposed of by the developer, does the developer cease to have any responsibility or any connection with the building thereafter?
Actually, once a developer completes the entire project, sells off all the units, at that first annual general meeting, it's very important that the developer hands over to the management corporation all the plans, the condominium plan, then the various you know, the approvals that they have got, the guarantees, warranties that they have got for various mechanical instruments, everything should be itemized, handed over to the council of the management corporation, and those are really valuable documents, because without those it will be very difficult for the council to maintain and attend to its task in the future. So developers' obligations would cease thereafter if they do the handing over properly, and if they have got proper warranties for all the mechanical aspects of the building, and if they have explained, actually there are lots of things that the developer should do, shouldn't just hand over and walk out. The developer must also help the CMA to nominate a responsible team as a council. And sometimes people who become council members really do not know what they ought to do. So most developers, at least for the first year, they take on the job of managing agent, and they maintain and manage the condominium properties. Some developers continue to be the managing agent for many periods thereafter. But that is also sometimes good, sometimes bad, because the developer could use that opportunity if the council and the unit owners are totally at a loss, they don't know what has been happening, then they would be at the mercy of the developer, and the developer could really one would not know how much money they are collecting, how much money is credited to the
utilized for
management fund. Management fund is the fund to which all these service charges are credited. And there's also a very important fund called a sinking fund, which is established by the developer before they hand over the project to the management corporation. This is money that is collected for major expenses of the condominium property. So those are, now if the developer continues to be the managing agent for many years, then the management corporation must of course obviously execute a agreement with the managing agent and very carefully include clauses so that they can monitor the work done by the managing agent, whether it's the developer or any other third party.
Now, ma'am, can anyone become a developer? Because we see so many properties coming up now, and developers are a dime a dozen everywhere, not only in Colombo but even in the outskirts. With increased urbanization, we see this happening. Is there any regulation of who can become a developer in Sri Lanka?
Actually, in our country, anyone who has the money and a block of land can become a developer of a multi-story building. But I must tell you, in Singapore, it's not so easy to be a developer of a high-rise building. I just want to mention this because I think we should have a similar system in our country. In Singapore, if a company is a developer, the company must have a minimum of 1 million to 1 to 3 million Singapore dollars as a paid up capital, and similar guarantee from a bank. Or if they are constructing a building of more than 10 units, then they are required to obtain a license. But in our country, there is no such mandatory requirement for a developer to have a license. So, as I told you, anyone can go ahead with it. And so, what I would say for prospective purchasers is, since we don't have this mandatory requirement for people to be a developer holding a license, one should check the background of a developer. What kind of projects have they done earlier, and has those projects been properly completed? Yeah, and also there's one other aspect. We have an authority called CEDA, Construction Industrial Development Authority. CEDA registers contractors, and there are certain, and categorizes them. So if it's a large high-rise building and if there are many units, at least the category of the contractor should be C2 upwards, C1, C2. So if you are putting down your money for a major high-rise, you need to also check whether the contractor, that is the developer's contractor, is registered with CEDA. And also their reputation, what kind of projects have they done earlier, and were these projects successful. So those are some of the important things that we should do in our country.
And something that as purchasers, what purchasers need to be wary of before they put down their hard earned money. Ma'am, now something that we see very often now is that even in residential areas, we see apartment complexes coming up. And sometimes it could be even on a small extent of land as maybe 8 to 10 pertus. Is there any specification on how large a plot of land should be, a minimum extent? And if so, what law governs that?
Yeah, this in the Colombo area, the construction of multi-story buildings is governed by the Colombo City Development Plan. What prevails right now is the 2008 plan, and it gives all the regulations that one has to observe. The extent of the plot of land, how close it should be to the road, what should be the width of the road, the adjoining road, and how many units in a particular block of land, and how high can the building be. So when a developer submits the building plan or the application for approval, that application should comply with all these regulations.
Right.
Now, regarding your question, at least it should be 40 purchase for a condominium property in the Colombo city area.
Right.
But if your building has only, let's say, 2 units,
Yes.
then there have been instances where they have given approval to do a condominium, because it will be basically house divided into 2, even on a 6 perch or 8 perch block of
Right.
land.
Right.
But then there is no necessity. But when you are doing a multi-story building, 10% of the land extent has to be kept for common areas, space from the front and the back.
Right.
So there are so many regulations that one has to observe when they go ahead with multi-story construction.
So these regulations, ma'am, where can they be found?
In the Colombo City Development Plan and in terms of the UDA law. So, but basically now when we talk about Colombo, it's the Colombo City Development Plan. But outside in Gaul, in Kandy, they too have plans. So if one needs to know, it's easiest thing is to check through the website what is the relevant plan, and then for a developer it's easier to check from maybe by visiting or accessing through the web what kind of regulations one has to comply with.
Because something that we notice now is when these multi-story buildings are coming up in residential areas, sometimes the residents complain that the roads are getting blocked, or their drainage is getting affected, the water pressure is getting affected, then they are not getting natural light into their homes. So how can the residents who are living in the surrounding areas, what can they do to ensure that their rights are not prejudiced?
Yeah. In the first instance, if such a project is next to your land or within your community, you need to find out from the authority whether they have given permission. Is there a development permit, right? These are public documents. One can go to the relevant authority and check. Because if now the authority would not grant a development permit without checking all these things.
Right.
The traffic congestion. Now if that area has more than 15 houses, then they would check the traffic impact. Is the road wide enough? Of course, even without traffic issues, whether there are water and sewage connections, without checking all those, the authority will not grant a permit.
Okay, thank you, ma'am. Now, you spoke about the apartment ownership law, and as someone who has been practicing in this area for years now, would you say that the apartment ownership law is comprehensive and is sufficient to meet all the issues that are faced by developers and owners alike?
The law was last amended in 2003. Now we are in 2019, almost 15 years have passed.
And much has changed
Much has changed. The skyline has changed a lot, and more projects are coming up. And as you said, neighbors find living in such environments difficult. So a lot of things needs to be done. So what was acceptable in 2003, what was necessary for condominium construction in 2003 has changed vastly now. So the law needs to be amended. And I think this is something that the authority and all people who really want to, have investors coming into the country should focus on. Now there are many areas that needs to be changed. As I told you, of course, apart from amending the law, the authority can do, issue regulations. Under the apartment ownership law, the authority has power to issue regulations, gazette regulations.
That's the condominium management authority.
Yes, under section 24 of the act. So now the one and only regulations that they have done so far was done in 2017. But in my view, they can do more. Like as I told you, for the sales agreement, what kind of minimum
mandatory
clauses that the developer should have. Then also where the apartment ownership law is concerned, now the provisional condominium registration, as I told you earlier, has not been made mandatory. So we have pre-sales, people putting down their hard-earned money, but there is no way that they can be comfortable
And
that
safeguard the
yeah,
investment.
because whatever they pay, put down as an installment is on a sketch that is shown by the developer. There is no proper condominium plan. Now, if there was a provisional condominium registration, then that plan would have got registered, and then of course folio would have been opened up at the land registry, so your sales agreement gets
Is
slotted into
registered
that
there.
folio.
Yes.
And here, when there is no such provisional registration, all the sales agreements gets registered on the main land. And when you go to the land registry, you will see hundreds of sales agreements. It's a huge encumbrance on the mainland.
Yes.
So provisional condominium registration should be made mandatory. And for pre-sales, as there are so many things that the law should be amended so that prospective purchasers' rights are safeguarded. Then most importantly, in our law too, they must make it mandatory for a developer to issue a disclosure statement.
Okay.
As I told you, in Western countries, developed countries, this is mandatory. And it's like a prospectus that is issued prior to a share issue. So this disclosure statement can be registered at the Condominium Management Authority, so it becomes a public document. That statement will give where the project will come up, in which zone, in the Colombo city, it's primary, residential, or then has this the developer obtained the development permit, or has an application been made, then has the other relevant documents been obtained, or when are they going to get it, and what is the size of the unit, what is the price, what are the fixtures and fittings, so what type of common elements and common amenities would be there, so service charge, all those things will be listed in the disclosure statement, making it really very transparent for anyone to be sure that this is the kind of a unit for which I should put my money.
Thank you so much, Ms. Edriman. Unfortunately, that is all we have time for. It is a vast area of law, and I'm sure, my dear viewer, that you would have found every single aspect that we covered this evening extremely beneficial. And we owe it to Ms. Edriman. We owe a great debt of gratitude to you for taking time off your busy schedule and all your speaking appointments to be with us this evening to share your expertise on this area. Thank you so very much.
Thank you for inviting me.
That is all we have time for, ladies and gentlemen. Thank you for joining us. I'm sure you benefited from everything we discussed this evening on vertical living. I do hope that you will join us once again next week for yet another edition of Law and Order. Good night.